The gavel cracks like a gunshot in courtroom 2B. Judge Thaddeus Braxton leans forward, his eyes cold as winter steel, surveying the woman before his bench like she's something he'd scrape off his shoe. Well, well, another entitled princess in designer clothes thinking the rules don't apply to her. Let me guess. You've got some sob story about why you're above a simple traffic citation. He doesn't see Dr. Celeste Montgomery, lead curator of African American history at the Smithsonian. He doesn't see a woman with 3 degrees and 2 decades of scholarly achievement. He sees exactly what he wants to see. A target. What Judge Braxton doesn't know is that this woman has access to the highest levels of federal law enforcement. What he's about to learn is that some people's patience has limits. And today, his time as a courtroom tyrant is about to expire. Dr. Celeste Montgomery sits perfectly straight, her hands folded, her voice steady as mountain stone. Your Honor, I'm here to contest Officer Wickham's citation because his report contains factual inaccuracies that I can prove. Braxton's sneer deepens. In his 15 years on this bench, he's perfected the art of crushing people's spirits. Today feels like any other day. He has no idea he's about to make the biggest mistake of his judicial career. The lock clicks twice, then silence. The morning had begun with methodical precision, exactly as Dr. Celeste Montgomery preferred. At 6:30 a.m., she reviewed acquisition reports in her pristine home office, cross-referencing authentication documents for a new collection of civil rights artifacts. Every detail mattered in her work. Provenance, historical context, the chain of custody that transformed objects into evidence of America's complex past. Her pen moved in careful annotations, each note reflecting decades of scholarly training that had taught her to question everything, verify sources, and never accept surface appearances. The drive to her meeting at the Smithsonian Institution's Conservation Lab should have been routine. Fairfax County's tree-lined streets stretched before her dark blue sedan, a sensible vehicle that reflected neither wealth nor poverty but simple professional competence. She observed the speed limit religiously, used turn signals even in empty intersections, and came to complete stops at every sign. These weren't just traffic habits, they were the systematic behaviors of someone who understood that details mattered, that precision was protection. If this story of judicial corruption and hidden power already has you on the edge of your seat, smash that like button. We're just getting started with this incredible true story. Make sure you're subscribed with notifications on because you won't want to miss how this David versus Goliath battle unfolds when the system thinks it has all the power. At Elm Street and Morrison Boulevard, she executed a flawless left turn, pausing 3 full seconds to ensure cross-traffic had cleared. The intersection sat empty except for a county police cruiser parked behind a utility pole, positioned with the tactical awareness of a predator studying prey. Officer Dane Wickham watched her approach through mirrored sunglasses, his patrol car's engine idling with mechanical patience. The traffic stop materialized with theatrical precision. Blue and red lights erupted in her rearview mirror barely 50 yards past the intersection, accompanied by the electronic wail of a siren that seemed disproportionately aggressive for the quiet residential neighborhood. Celeste guided her vehicle to the curb with the same methodical care she applied to everything else. Hands visible on the steering wheel, registration and insurance documentation already retrieved from the glove compartment. Officer Wickham approached with the swagger of absolute authority, his hand resting casually on his service weapon despite the obvious absence of any threat. He was young, perhaps late 20s, with the kind of aggressive confidence that masked deeper insecurities about power and respect. License and registration. The demand came without preamble, without explanation, delivered in the flat monotone of someone who expected immediate compliance. Celeste handed over the documents with practiced calm, her expression neutral despite the growing awareness that something was fundamentally wrong with this encounter. Wickham studied her driver's license with exaggerated scrutiny, his eyes moving between the photograph and her face as if searching for evidence of forgery. The pause stretched longer than professional necessity required, designed to establish dominance through uncomfortable silence. "This your vehicle, ma'am?" The question carried unmistakable implications. Not, "Is this vehicle registered to you?" but the more loaded inquiry that suggested ownership might be questioned, legitimacy challenged. Celeste felt the familiar weight of assumptions settling around her like smoke, but her voice remained perfectly controlled. "Yes, officer, the registration is in my name." "You know why I stopped you?" Another pause, another opportunity for intimidation. Wickham's posture radiated the satisfaction of someone who believed he held all the cards, who could shape this encounter according to his preferences and prejudices. "I'm not certain, officer. I was observing all traffic regulations. Failure to yield at the intersection back there. You made that turn without proper clearance. Celeste's mind immediately processed the accusation, running it against her precise memory of the maneuver. She had waited 3 seconds, checked all directions twice, proceeded only when the intersection was completely clear. More importantly, she knew the traffic regulations better than most people realized. "Officer, I came to a complete stop and verified the intersection was clear before proceeding. Virginia Code Section 18.2-308 requires a full stop and reasonable caution, both of which I observed." Wickham's expression hardened behind his sunglasses. Citizens weren't supposed to cite traffic statutes back to him, especially citizens who looked like her. The casual confidence in her legal citation suggested education, preparation, and worst of all from his perspective, the audacity to challenge his authority. "Ma'am, I've been doing this job for 6 years. I know what I saw. I understand your experience, officer. However, I also have dashcam footage that recorded the intersection approach." The words landed like physical blows. Wickham's casual superiority cracked, replaced by something harder and more defensive. Citizens with dashcams were problematic. Citizens with dashcams who understood traffic law were dangerous. "You threatening me with some camera?" "I'm not threatening anyone, officer. I'm simply stating that I have objective evidence of my driving behavior." "Let me tell you something, lady. You people always think you know better than law enforcement. Always got some excuse, some story about why the rules don't apply to you." There it was. The mask slipped completely, revealing the ugly assumptions that had driven this encounter from the beginning. "You people." 2 words that carried centuries of weight, decades of discrimination dressed up as law enforcement. Celeste maintained her composure despite the racial undertones that now poisoned the air between them. She had faced this kind of bias before, in academic conferences, museum board meetings, and countless other situations where her competence was questioned before her identity was known. The key was documentation, evidence, and the patient accumulation of facts that could speak louder than prejudice. "Officer, I would like to exercise my right to contest this citation if you choose to issue one." Wickham stalked back to his patrol car, his radio chatter too distant to hear clearly, but his body language radiating frustrated anger. He was making a calculation now, weighing the satisfaction of teaching this woman a lesson against the potential complications of dealing with someone who obviously wasn't going to accept his authority quietly. 20 minutes passed. Other drivers slowed to observe the scene, some with curiosity, others with the nervous recognition that traffic stops in affluent neighborhoods carry different implications depending on who was being stopped. An elderly white woman walking her dog paused to watch from the sidewalk, her expression suggesting disapproval directed not at the officer but at the disruption Celeste's presence had caused to the community's peaceful routine. When Wickham returned, he carried a citation book and an expression of grim satisfaction. He had decided to push forward, confident that the system would support his version of events regardless of contradictory evidence. "Sign here." The citation detailed failure to yield, carrying a fine of $485 and 2 points on her driving record. The amount was substantial enough to cause financial hardship for many people, and the points would affect insurance rates for years. It was punishment designed to be accepted rather than challenged, the kind of bureaucratic bullying that relied on citizens' reluctance to navigate the court system. Celeste signed the citation with the same careful precision she applied to museum authentication forms. Her signature was clear, legible, and accompanied by a mental note to compile every piece of available evidence for the inevitable court appearance. "Your court date's on there if you want to waste everybody's time fighting it." Wickham delivered the parting shot with obvious relish, convinced that he had successfully established his dominance over someone who had dared to challenge his authority. He had no way of knowing that this particular citizen possessed resources and connections that extended far beyond his experience or imagination. As the patrol car disappeared around the corner, Celeste sat quietly in her vehicle, processing the encounter with the analytical skills that had made her reputation as a historian. This wasn't random. The intersection positioning, the aggressive questioning, the racial undertones, and the dismissal of evidence all suggested a pattern of behavior that extended beyond simple traffic enforcement. She drove home slowly, observing every traffic regulation with even greater care than usual. The citation lay on her passenger seat like a challenge, its bureaucratic language masking the personal nature of the confrontation. $485 and 2 points were trivial compared to the larger questions it raised about justice, accountability, and the daily experiences of people who didn't have her advantages. That evening, her husband found her in their kitchen. The citation spread on the granite countertop beside printed copies of Virginia traffic statutes and a laptop displaying dashcam footage. Marcus Montgomery, director of the Federal Bureau of Investigation, recognized his wife's research mode immediately. She had assembled evidence with the same methodical thoroughness that characterized her professional work. How was your day? Celeste looked up from her documentation, meeting his tired eyes with the calm expression that had sustained her through decades of academic and personal challenges. I was profiled. Marcus read the citation, his expression growing harder with each line. He understood traffic stops from both sides. As a black man who had experienced his share of questionable encounters, and as a federal law enforcement executive who knew exactly how such encounters should be conducted. 485 for failure to yield? That's excessive. I didn't fail to yield. I have video proof. Marcus sat down heavily, loosening his tie with the gesture of a man carrying the weight of institutional responsibility. He knew his wife well enough to recognize when she had made a decision, and he could see in her posture that she wasn't going to let this pass quietly. The system isn't built for this kind of challenge, Celeste. Traffic court is designed to process citations quickly. Most judges will defer to officer testimony regardless of evidence. Then the system needs to be challenged. Her voice carried the quiet intensity that Marcus had first fallen in love with during their law school days at Howard University. Celeste never backed down from principle, never accepted injustice simply because fighting it was inconvenient. It was one of her greatest strengths and occasionally one of his greatest worries. Judge Thaddeus Braxton handles traffic court in Fairfax County. He's got a reputation. Marcus's tone carried warnings layered beneath simple information. Braxton was known in law enforcement circles as a difficult judge. Someone who treated his courtroom like a personal kingdom and defendants like subjects to be managed rather than citizens with rights. What kind of reputation? The kind where you might want to consider just paying the fine. Celeste studied her husband's face, reading the conflict between his personal support for her and his professional understanding of institutional realities. Marcus dealt with judges, prosecutors, and law enforcement agencies across the country. He knew which battles could be won and which ones carried costs that extended beyond individual cases. I'm going to fight this, Marcus. And I'm going to do it without mentioning your name or position. The decision was final, delivered with the same calm certainty she brought to authentication decisions at the museum. Marcus recognized that tone and knew better than to argue further. Be careful, please. I'm always careful. She returned to her research, pulling up case law and judicial conduct guidelines while Marcus watched with a mixture of admiration and apprehension. Tomorrow would bring a court appearance that could easily be resolved with a simple payment, but Celeste had never chosen the easy path when principle was at stake. Outside their window, Fairfax County settled into another quiet evening, its tree-lined streets and well-maintained neighborhoods projecting an image of ordered prosperity. Beneath that surface, systems and individuals prepared for confrontations they didn't yet understand, for challenges to authority that would reveal the true nature of justice in America. The Fairfax County General District Court building squatted like a bureaucratic fortress at the intersection of Chainbridge Road and Courthouse Plaza, its red brick facade attempting to suggest colonial dignity while achieving only institutional intimidation. Dr. Celeste Montgomery approached the main entrance at 8:45 a.m., allowing 15 minutes to navigate security and locate courtroom 2B. She carried a leather portfolio containing dashcam footage, printed traffic statutes, and a detailed timeline of yesterday's encounter with Officer Wickham. The security checkpoint processed her with mechanical efficiency, metal detectors and X-ray machines operated by court personnel who had perfected the art of looking through people rather than at them. Celeste's professional attire, a charcoal gray suit with modest jewelry and low heels, marked her as someone who understood courtroom protocols, but her skin color ensured she received the same suspicious scrutiny applied to defendants facing more serious charges. Courtroom 2B buzzed with the nervous energy of people confronting the justice system on its home territory. Approximately 40 citizens filled wooden benches designed for uncomfortable waiting, their cases representing the daily grinding work of municipal law enforcement. Speeding tickets, parking violations, minor infractions that generated revenue and reinforced social hierarchies. Most defendants appeared to be working-class people who had calculated that a day off work was cheaper than fighting citations. Resignation etched in their postures as they waited for administrative processing disguised as judicial proceedings. Speaking of protecting yourself from false accusations, Legal Shield offers 24/7 access to experienced attorneys who can help you navigate traffic stops, workplace discrimination, and civil rights violations. For less than $1 a day, you get legal consultation, document review, and representation when you need it most. Visit LegalShield.com and use code JUSTICE for your first month free. Because everyone deserves legal protection regardless of their connections. Public defender Iris Wainwright occupied a corner table, her case files stacked in precarious towers that suggested chronic understaffing and impossible caseloads. She was younger than Celeste had expected, probably early 30s, with the kind of determined exhaustion that characterized overworked advocates in underfunded systems. Occasionally, she glanced up from her paperwork to study the gallery, making quick assessments about which defendants might need her services and which could navigate the system independently. At 9 o'clock precisely, Bailiff Royce Ashford called the courtroom to order with military precision. He was a large man, mid-50s, whose bearing suggested law enforcement background and whose expression indicated someone who had learned to follow orders without asking unnecessary questions about their justice or morality. All rise for the Honorable Judge Thaddeus Braxton. The gallery stood with the rustle of nervous clothing and whispered prayers, 40-plus people hoping for mercy from a system designed more for efficiency than fairness. Judge Braxton entered from a side door with the theatrical flourish of someone who understood that power was as much performance as authority. Thaddeus Braxton was 62 years old, with silver hair that caught courtroom lighting like a crown, and pale blue eyes that seemed perpetually focused on distant horizons of superiority. His black judicial robe hung perfectly tailored on a frame kept trim by expensive gym memberships and entitled confidence. He carried himself with the aristocratic bearing of old Virginia money, someone whose family had held power when power meant something different than it did today. He settled into his elevated chair with the satisfied air of a king ascending his throne, surveying his subjects with the kind of casual disdain that came from 15 years of absolute authority within these four walls. His gaze passed over the gallery like a searchlight, cataloging defendants according to categories that had nothing to do with legal guilt or innocence. Mr. Donovan, let's proceed efficiently today. I have a golf appointment at 2 o'clock. District Attorney Sterling Pembroke occupied the prosecution table with his assistant and a stack of case files that represented the morning's work. He was younger than Braxton, mid-40s, with the kind of political ambition that made challenging judges inadvisable regardless of circumstances. His relationship with Braxton appeared comfortable, familiar, the kind of professional partnership that developed when mutual interests aligned. The first cases proceeded with assembly line efficiency that prioritized speed over scrutiny. A construction worker pleaded guilty to speeding, accepting a $200 fine because fighting would cost more in lost wages. A college student attempted to explain why her registration had expired, only to be cut off by Braxton's impatient wave. Guilty. $150 plus court costs. Pay the clerk. Next. An elderly Hispanic man approached the podium with his adult daughter serving as translator. Their English limited, but their desire to understand the proceedings obvious. Braxton's expression hardened with visible irritation at the complication their presence represented. This is an American courtroom, English only. If you can't understand the charges, you shouldn't have been driving. The daughter tried to explain that her father had simply forgotten to renew his inspection sticker, that he was a law-abiding citizen who had never received a traffic citation before. Braxton's response carried undertones that extended beyond judicial impatience. $300. And if I see him back here for any reason, we'll discuss more serious consequences. Celeste watched the pattern emerge with growing unease. Braxton's treatment of defendants followed predictable lines that had nothing to do with the severity of infractions or the quality of explanations. Working-class people, minorities, and anyone who showed insufficient deference received harsher treatment than those who projected middle-class respectability and appropriate submission. Public Defender Wainwright attempted to intervene on behalf of a young black man facing suspension of his driver's license, which would cost him his job delivering medical supplies to nursing homes. Her argument was brief, professional, and focused on the disproportionate impact of license suspension on someone whose employment required driving. Your Honor, my client's work provides essential services to elderly residents who depend on timely medication delivery. Perhaps we could consider community service instead of suspension. Braxton leaned forward with predatory interest, his voice dropping to a register that suggested personal offense at being questioned. Miss Wainwright, are you suggesting this court doesn't understand the appropriate consequences for traffic violations? Are you implying that your client's employment is more important than public safety? No, Your Honor. I'm simply requesting consideration of alternative sentencing that would serve justice while preserving his ability to continue serving the community. License suspended for 90 days. Maybe next time he'll remember that driving is a privilege, not a right. Next case. The young man's shoulders sagged with the weight of economic disaster. 3 months without driving meant unemployment, which meant inability to pay rent, which meant a spiral into poverty that would affect his family for years. Braxton had delivered this sentence with the casual indifference of someone ordering coffee, Celeste observed these interactions with the analytical skills that made her reputation as a historian. She was witnessing the operation of a system that functioned exactly as designed, not to dispense justice, but to maintain existing power structures while generating revenue through the efficient processing of minor infractions. The law was secondary to the larger project of social control. Case number 304B, Commonwealth versus Celeste Montgomery. Bailiff Ashford's voice carried across the courtroom with official neutrality. But Celeste noticed several gallery members turning to observe her approach to the defendant's podium. She was clearly different from the morning's previous defendants, better dressed, more educated, carrying herself with professional confidence rather than defensive uncertainty. Judge Braxton looked up from his paperwork, his assessment beginning before she had fully reached the podium. His eyes traveled from her shoes to her face, cataloging details with the thoroughness of someone making important decisions based on appearances rather than evidence. The expensive leather of her portfolio, the quality of her suit fabric, and most importantly, the composed way she carried herself all registered in his consciousness as challenges to his authority. She was not sufficiently intimidated. She was not appropriately humble. She projected competence rather than deference. And in Braxton's experience, competent citizens were invariably troublesome citizens. Dr. Celeste Montgomery, he announced, pronouncing her name with subtle distortion that stripped it of dignity, charged with failure to yield under Virginia Code 18.2-308. How do you plead? His tone carried expectations. Guilt was assumed, the proceeding was administrative, and her role was to accept whatever sentence he deemed appropriate. The question was ritual rather than inquiry. Not guilty, Your Honor. The words hit the courtroom like cold water on hot glass. Gallery members shifted with surprise, a few heads turning to stare at the woman bold enough to challenge the system's basic assumptions. Public Defender Wainwright looked up from her notes with newfound interest. Even District Attorney Pembroke paused his shuffling through case files to focus on this unexpected complication. Judge Braxton's expression underwent subtle transformation, his casual superiority replaced by something sharper and more focused. Citizens weren't supposed to plead not guilty to traffic infractions. They were supposed to accept responsibility, pay their fines, and disappear back into the anonymity from which they had emerged. Not guilty. His voice carried disbelief colored by emerging irritation. Miss Montgomery, are you represented by counsel? I am representing myself, Your Honor. I see. And you understand that fighting a simple traffic citation will likely cost you more in time and energy than simply accepting responsibility for your actions. The question wasn't legal advice. It was intimidation disguised as wisdom, an attempt to pressure her into conformity through the suggestion that resistance was futile. Braxton had perfected this technique over 15 years of crushing citizen complaints before they could develop into challenges to his authority. I understand the costs, Your Honor. I also understand my rights under the Constitution and Virginia law. Another ripple of surprise passed through the gallery. Citizens weren't supposed to cite constitutional rights in traffic court. They weren't supposed to demonstrate legal knowledge that complicated the simple narrative of guilt and punishment that kept the system running efficiently. Braxton's irritation intensified, his voice taking on the edge that warned of escalating consequences for continued defiance. Very well. Officer Wickham, please take the stand. Officer Dane Wickham strode to the witness stand with confident swagger, his uniform pressed to military precision and his expression radiating the comfortable authority of someone accustomed to having his word accepted without question. He was sworn in with mechanical efficiency, hand raised briefly before settling into the witness chair with proprietary ease. District Attorney Pembroke approached with a file folder and the routine of someone who had conducted this same examination hundreds of times. The questions were standardized, the answers predictable, the outcome predetermined by institutional assumptions about police credibility versus citizen reliability. Officer Wickham, please describe the events of yesterday afternoon. At approximately 3:45 p.m., I was conducting traffic enforcement at the intersection of Elm Street and Morrison Boulevard. I observed the defendant's vehicle approach the intersection and failed to come to a complete stop before turning left onto Morrison. The defendant executed what we call a rolling stop, slowing down but not bringing her vehicle to full cessation before proceeding. Wickham's testimony flowed with practiced smoothness, each word carefully chosen to support the citation while avoiding language that might invite challenge or cross-examination. He had given this type of testimony countless times, refining his presentation to sound authoritative while remaining vague enough to resist contradiction. Was your view of the intersection unobstructed? Yes, sir, completely clear. I had perfect visibility of the defendant's approach and turn. And you're certain she failed to come to a complete stop? Absolutely certain. I've been conducting traffic enforcement for 6 years, and I know the difference between a complete stop and a rolling stop. Pembroke nodded with satisfaction, his questions designed to establish Wickham's credibility while avoiding any details that might complicate the simple narrative of violation and enforcement. Thank you, officer. Your witness. The invitation for cross-examination hung in the air like a challenge. This was the moment when most pro se defendants either accepted defeat or made emotional appeals that only reinforced their guilt in judicial eyes. Judge Braxton leaned back in his chair with the satisfied anticipation of someone about to witness another citizen's humiliation. Celeste approached the witness stand with measured steps, her portfolio held professionally but not defensively. She had conducted academic presentations before hostile audiences, defended dissertation research against skeptical committees, and navigated museum politics that would challenge seasoned diplomats. Cross-examining a traffic officer represented a different kind of intellectual challenge, but not an unprecedented one. Officer Wickham, you testified that you observed my vehicle from a position at Elm Street and Morrison Boulevard. Could you describe your exact location more specifically? Wickham shifted slightly, his casual confidence encountering the first hint of scrutiny that went beyond routine questions. I was parked on Morrison, approximately 50 yards east of the intersection. 50 yards. And from that distance and angle, you could definitively observe whether my front tires completely stopped rotating? Yes, ma'am. As I testified, I had clear visibility. Officer, I'm curious about your training in vehicle observation techniques. Have you received specific instruction in determining complete stops versus rolling stops from distances of 50 yards or more? The question carried implications that made Pembroke shift uncomfortably in his chair. Citizens weren't supposed to challenge police training or expertise, weren't supposed to possess enough knowledge to make such challenges sound credible. I've received standard traffic enforcement training, ma'am. Standard training. And does that training include specific protocols for documenting intersection stops? Particularly procedures for confirming complete cessation of vehicle movement from extended distances? Wickham's composure began showing stress fractures. The questions were too specific, too informed, suggesting knowledge that exceeded normal citizen expectations. Ma'am, I know what I observed. I'm sure you believe that, officer. But belief and objective fact aren't always identical, are they? Judge Braxton's patience evaporated with explosive force. That's enough. Miss Montgomery, this isn't a legal seminar. Ask your questions or sit down. The judicial intervention was designed to protect Wickham from further embarrassment while reasserting courtroom hierarchy. Braxton wasn't going to allow this citizen to continue demonstrating knowledge that complicated his preferred narrative of police infallibility and citizen guilt. Your Honor, I'm simply attempting to establish the reliability of Officer Wickham's observations under the specific circumstances of this traffic stop. His observations are presumed reliable, Miss Montgomery. He's a trained law enforcement professional. And I'm a citizen with constitutional rights, including the right to confront the evidence against me. The words struck the courtroom like lightning, momentarily stunning everyone with their audacity. Citizens weren't supposed to cite constitutional principles in traffic court, weren't supposed to challenge the basic assumptions that kept the system functioning smoothly. Braxton's face flushed with color that suggested mounting blood pressure and diminishing self-control. He had spent 15 years crushing exactly this kind of defiance, and he wasn't about to allow it to succeed now. Miss Montgomery, you're dangerously close to contempt of court. Your Honor, I'm exercising my rights under the Sixth Amendment and Virginia Code Section 19.2-164. The legal citations landed like bombs in the quiet courtroom. Gallery members who had never heard constitutional amendments mentioned in traffic proceedings leaned forward with newfound attention. Public Defender Wainwright stopped pretending to work on other cases, focusing completely on this unprecedented confrontation between citizen knowledge and judicial authority. The atmosphere in courtroom 2B had transformed from routine administrative processing to something electric with tension and possibility. What began as a simple traffic citation was evolving into a confrontation between institutional power and individual rights, with implications that extended far beyond the $485 fine at stake. Judge Braxton gripped his gavel with white-knuckled intensity, his carefully maintained judicial demeanor cracking under pressure from a defendant who refused to accept his authority without question. 15 years of unchallenged power had not prepared him for someone who possessed both the knowledge and courage to cite constitutional law in response to his intimidation tactics. Officer Wickham, Celeste continued with steady professionalism, you mentioned 6 years of traffic enforcement experience. During that time, have you ever encountered situations where initial observations proved incorrect upon closer examination? The question carried deadly implications wrapped in academic courtesy. Wickham understood that his credibility was under attack, but he lacked the sophistication to recognize the legal trap being constructed around his testimony. Ma'am, I know what I saw. I'm sure you believe that. But human perception can be affected by various factors: distance, lighting conditions, preconceived expectations. Isn't that why many police departments now require body cameras for traffic stops? District Attorney Pembroke half rose from his chair, sensing the direction of the cross-examination but uncertain how to intervene without appearing to protect a witness who should be able to defend his own observations. Objection, Your Honor. Relevance. Sustained, Braxton snapped. But his intervention lacked conviction. The question was clearly relevant to the reliability of Wickham's testimony, and everyone in the courtroom understood that. Officer Wickham, do you wear a body camera during traffic stops? Yes, ma'am. Department policy requires it. And was your body camera recording during my traffic stop yesterday? Wickham's hesitation stretched just long enough to suggest complications with a question that should have prompted an immediate affirmative response. There was a technical malfunction with my equipment yesterday. A malfunction? How convenient. Celeste's voice remained professionally neutral, but the implications of her words echoed through the courtroom like accusatory thunder. And this malfunction occurred specifically during the period when you observed my alleged traffic violation? The camera stopped working earlier in my shift. I see. And you didn't request replacement equipment or return to the station to address this malfunction? I continued my shift according to department protocols. The evasiveness in Wickham's responses was becoming obvious even to gallery members with no legal training. His story was developing inconsistencies that suggested either gross negligence or deliberate deception. Can you imagine the frustration and humiliation Dr. Montgomery must be feeling right now? The system is supposed to protect everyone equally, but here she is being railroaded by corruption. If you've ever felt powerless against injustice, drop a comment below sharing your story. Hit that like button if you believe everyone deserves equal treatment under the law, regardless of who they are. Judge Braxton recognized the deteriorating situation and decided to assert control through judicial authority rather than allow the cross-examination to continue exposing weaknesses in the prosecution's case. That's sufficient, Miss Montgomery. The court finds Officer Wickham's testimony credible and reliable. Your Honor, I haven't finished my cross-examination. Yes, you have. I've heard enough. The arbitrary termination of cross-examination violated basic due process rights. But Braxton was more concerned with protecting his authority than observing constitutional requirements. He had presided over this courtroom for 15 years by ensuring that challenges to the system were crushed before they could develop into precedents. Your Honor, I respectfully request the opportunity to present evidence in my defense. Celeste's request was delivered with calm professionalism that contrasted sharply with Braxton's increasingly agitated demeanor. She opened her portfolio and withdrew a USB drive containing dash cam footage that would definitively resolve the factual dispute about her driving behavior. What is that? Braxton demanded, his voice carrying the suspicion of someone who had learned to distrust evidence that might contradict official narratives. Dash cam footage from my vehicle, Your Honor. It shows the intersection approach and my complete stop before turning. The mention of objective video evidence sent ripples of tension through the courtroom. Gallery members leaned forward with interest, understanding that technological documentation might trump official testimony. Public Defender Wainwright abandoned her other cases entirely, recognizing that this confrontation might establish precedents affecting future clients. This court doesn't have facilities for viewing video evidence, Braxton announced with obvious satisfaction at having discovered a procedural obstacle to inconvenient truth. Your Honor, the court has a laptop computer and projection system that are used for other proceedings. Virginia Code Section 8.01-412 requires courts to consider all relevant evidence presented by defendants in criminal and traffic cases. Celeste's knowledge of courtroom equipment and legal requirements demonstrated preparation that extended far beyond typical pro se defendants. She had researched not only traffic law but also courtroom procedures, evidence rules, and judicial responsibilities. Miss Montgomery, this is a traffic court, not a trial. Different rules apply. Your Honor, traffic violations are criminal offenses under Virginia law, and defendants retain constitutional rights regardless of the severity of charges. The constitutional law citation hit Braxton like a physical blow. He was being lectured about legal principles by someone he had initially dismissed as another entitled citizen trying to avoid responsibility. Her knowledge was too extensive, too specific, suggesting background that went beyond internet research or casual familiarity with legal concepts. Court Clerk Meredith Vale had been observing the proceedings with growing unease, recognizing that the confrontation was escalating beyond normal parameters. She approached the bench with whispered communication that Celeste couldn't hear, but could interpret from Braxton's darkening expression. Miss Montgomery, The court lacks technical capabilities to review video evidence today. If you wish to present this footage, you'll need to schedule a separate hearing. The delay tactic was transparent. Most citizens would be unable or unwilling to return for additional court appearances, effectively excluding evidence that might exonerate them. It was institutional bullying disguised as procedural necessity. Your Honor, I can provide technical assistance to set up the equipment. The video is less than 5 minutes long and directly relevant to the charges against me. Braxton's fury was becoming visible, his face flushing with color that suggested dangerous blood pressure levels. He was being challenged by someone who refused to be intimidated, who possessed knowledge that neutralized his usual tactics, and who had evidence that might expose the false nature of the charges against her. The court has made its ruling regarding evidence. This case will proceed based on Officer Wickham's testimony. Your Honor, excluding relevant evidence without reviewing it violates due process rights under the 14th Amendment. Constitutional citations were the final straw for Braxton's deteriorating self-control. He had crushed hundreds of defendants over the years, but none had possessed the knowledge and courage to cite constitutional law while challenging his authority in front of a full courtroom. That's it! He slammed his gavel with explosive force. Miss Montgomery, you are in contempt of this court. The contempt charge was his nuclear option, the ultimate weapon for silencing defiant citizens who refused to accept his absolute authority. It carried potential jail time, substantial fines, and most importantly, the power to crush resistance through institutional force. On what grounds, Your Honor? Celeste's calm response to the contempt threat demonstrated either remarkable courage or dangerous naivety. Most citizens would have immediately apologized and accepted whatever sentence he imposed, but she was continuing to challenge his authority even when facing potential imprisonment. Disrespect to this court, failure to follow judicial instructions, and persistent disruption of court proceedings. Your Honor, I have been respectful throughout these proceedings. I have cited relevant law and attempted to present evidence. I have not raised my voice or used inappropriate language. I have simply exercised constitutional rights that belong to all citizens. Her response was delivered with professional calm that made Braxton's emotional volatility more obvious by contrast. Gallery members were witnessing a confrontation between someone who understood both law and appropriate courtroom behavior, and someone who was abusing judicial power to silence legitimate challenges to his authority. Public Defender Wainwright stood with obvious reluctance, understanding that intervening might protect her future clients but would certainly anger the judge she dealt with daily. Your Honor, if I may address the court briefly. Sit down, Miss Wainwright. This doesn't concern you. The dismissal was harsh enough to cause Wainwright to flinch, but she remained standing with the kind of professional courage that characterized public defenders who genuinely cared about their clients' rights. Your Honor, due process requires that defendants be allowed to present evidence and cross-examine witnesses. Miss Montgomery appears to be exercising these rights appropriately. Braxton's rage now had two targets: the defendant who refused to submit to his authority, and the public defender who had the audacity to support constitutional rights over judicial convenience. Miss Wainwright, if you continue to interfere with court proceedings, you'll join Miss Montgomery in contemplating the wisdom of challenging this court's authority. The threat to jail a public defender for advocating constitutional rights crossed lines that even Braxton's corrupt system rarely approached. Court reporter Eden Cross looked up from her stenography machine with obvious alarm, understanding that she was documenting judicial misconduct that could have serious consequences. Bailiff Royce Ashford shifted uncomfortably near the courtroom entrance, his hand moving unconsciously toward his service weapon despite the absence of any physical threat. The situation was escalating beyond normal parameters, and his training had not prepared him for confrontations between judges and citizens who cited constitutional law. Your Honor, Celeste said with steady calm, I request that you recuse yourself from this case due to obvious bias and prejudicial statements. The recusal request was the ultimate challenge to Braxton's authority, a direct accusation of judicial misconduct that threatened his power and possibly his career. Judges were required to recuse themselves when their impartiality might reasonably be questioned, but few citizens possessed the knowledge or courage to make such requests. Absolutely not. This court is perfectly capable of handling traffic cases without instruction from defendants about judicial ethics. Your Honor, Canon 3 of the Virginia Code of Judicial Conduct requires judges to perform duties impartially and without bias. Your statements about this court's authority suggest predetermined conclusions about my guilt. Celeste's citation of judicial ethics codes was professional dynamite in the quiet courtroom. She was not only challenging his specific rulings but questioning his fitness to serve as a judge. using official ethics standards as weapons against his misconduct. The gallery members were witnessing something unprecedented, a traffic defendant who appeared to understand legal principles better than the judge presiding over her case. Some observed with fascination, others with the nervous awareness that they were seeing institutional power challenged by individual knowledge and courage. Miss Montgomery, you've earned yourself 30 days in jail for contempt, plus the maximum fine for your traffic violation. Braxton's sentence was delivered with sadistic satisfaction, the culmination of 15 years of crushing defiant citizens who dared to challenge his absolute authority within the confines of courtroom 2B. Your Honor, I respectfully appeal this sentence and request immediate release pending review by the Virginia Court of Appeals. Even in the face of threatened imprisonment, Celeste maintained professional composure while demonstrating knowledge of appellate procedures that suggested legal training or extensive preparation. Her calm response to judicial bullying was beginning to unnerve even Braxton, who had expected emotional breakdown or immediate capitulation. There is no appeal from this court's contempt authority. Your Honor, Virginia Code Section 18.2-456 provides for immediate appellate review of contempt orders, particularly when constitutional rights are at stake. The legal citation was accurate, specific, and delivered with the confidence of someone who had researched judicial misconduct procedures thoroughly. Braxton was discovering that his usual tactics for silencing troublesome defendants were ineffective against someone who understood both her rights and his obligations. Bailiff, take Miss Montgomery into custody. The order to arrest a traffic defendant for exercising constitutional rights represented the complete breakdown of judicial restraint. Ashford approached the defendant's podium with obvious reluctance, understanding that he was being ordered to participate in what might later be recognized as a civil rights violation. Ma'am, you'll need to come with me. Celeste gathered her portfolio with methodical care, her movements suggesting someone who had anticipated this possibility and prepared accordingly. She was not surprised by Braxton's escalation to imprisonment. She was documenting it. Officer Ashford, before you proceed with this arrest, I want to ensure that you understand the full implications of what you're being asked to do. Her voice carried new authority that made Ashford pause mid-step. She was no longer speaking as a defendant pleading for mercy, but as someone who possessed knowledge and resources that might affect his career and future. Ma'am, I'm following court orders. I understand your position, but I want you to know that this arrest will be reviewed by federal authorities, and your role in violating constitutional rights may have consequences that extend beyond this courtroom. The mention of federal review sent shockwaves through the courtroom. Gallery members straightened with sudden attention, recognizing that the stakes had just escalated beyond local judicial politics. Court personnel exchanged nervous glances, understanding that their actions were being scrutinized by someone who possessed resources for challenging institutional misconduct. Braxton's face underwent a series of color changes that suggested internal pressure approaching dangerous levels. He had expected immediate compliance with his arrest order, not continued defiance backed by threats of federal intervention. Miss Montgomery, are you threatening this court with federal action? I'm not threatening anyone, Your Honor. I'm simply informing court personnel that constitutional violations may be subject to federal review under 18 U.S.C. Section 242. Just like Dr. Montgomery kept her identity private until the right moment, you should protect your personal information from identity thieves and data breaches. LifeLock monitors your credit, scans the dark web for your personal data, and provides up to $1 million in stolen funds reimbursement. Right now, save up to 25% off your first year at LifeLock.com with promo code PROTECT. Your identity is your most valuable asset. Guard it like your life depends on it. The federal statute citation was delivered with casual precision that suggested familiarity with civil rights law extending far beyond typical citizen knowledge. Everyone in the courtroom understood that 18 U.S.C. Section 242 dealt with federal prosecution of officials who violated constitutional rights under color of law. Ashford stopped his advance toward the defendant's podium, his law enforcement training recognizing that the situation had developed complications requiring supervisory input. Arresting someone who was citing federal civil rights statutes might create problems that exceeded his authority to resolve. Your Honor, perhaps we should, bailiff, carry out my orders immediately. Braxton's insistence on proceeding with the arrest despite obvious legal complications revealed the depth of his commitment to maintaining absolute authority regardless of consequences. He had ruled Courtroom 2B as personal kingdom for 15 years, and he wasn't going to allow constitutional law to interfere with his power now. Bailiff Ashford, Celeste said with quiet intensity, Before you place me under arrest for exercising constitutional rights, I think there's something you need to know about who you're arresting." The words carried implications that made everyone in the courtroom freeze with anticipation. Her calm demeanor in the face of imprisonment, her extensive legal knowledge, and her references to federal review suggested resources and connections that extended beyond typical citizen capabilities. Ashford looked between the judge and the defendant, recognizing that he was caught between competing authorities with potentially career-ending consequences regardless of his choice. His hand moved away from his handcuffs as survival instincts overrode automatic obedience to judicial orders. "Your Honor, maybe we should consider—" "Bailiff, if you don't arrest this defendant immediately, you'll be facing disciplinary action for failure to follow court orders." The threat to discipline Ashford for hesitating revealed Braxton's desperation to maintain control of a situation that was spiraling beyond his experience or competence. He was discovering that institutional power had limits when confronted by someone who understood both legal rights and federal authority structures. "Judge Braxton," Celeste said, her voice carrying new authority that made several gallery members gasp with recognition. "Before you take this final irrevocable step, I strongly advise you to reconsider." The shift in her tone was subtle but unmistakable. She was no longer speaking as a defendant pleading for justice, but as someone issuing a warning from a position of authority that transcended his judicial power. The change was so dramatic that even Braxton hesitated, sensing danger without understanding its source. "Are you threatening me in my own courtroom?" "I'm not threatening you, Judge. I'm advising you. You're about to make a catastrophic mistake that will have consequences extending far beyond this traffic citation." Her calm certainty in the face of threatened imprisonment suggested either remarkable courage or knowledge of resources that could neutralize his authority. Braxton was discovering that his usual tactics for crushing defiant citizens were encountering resistance that he had never experienced before. The courtroom had fallen completely silent, 40-plus gallery members and court personnel recognizing that they were witnessing something unprecedented, a confrontation between judicial power and individual authority that might redefine their understanding of both. The tension was electric, with implications that extended far beyond the $485 fine that had started this confrontation. "Bailiff, arrest this defendant now, or face the consequences of disobeying court orders." Ashford approached the defendant's podium with reluctant steps, his training in conflict with his instincts about the dangerous territory he was entering. He was being ordered to arrest someone who appeared to possess federal connections and extensive legal knowledge. Someone whose threats about constitutional violations and federal review carried the weight of authority rather than desperation. "Ma'am, I'm sorry, but I have to follow court orders. Officer Ashford, I understand your position. But before you place those handcuffs on me, there's something Judge Braxton needs to know about the person he's ordering you to arrest." She reached slowly into her portfolio, not for the dashcam evidence that had started this confrontation, but for something that would transform every assumption underlying the past 40 minutes of judicial proceedings. Her movement was deliberate, unhurried, suggesting someone who had anticipated this moment and prepared accordingly. "What is that?" Braxton demanded, his voice revealing the first hints of genuine uncertainty about his control of the situation. "This," Celeste said, removing a leather credentials case from her portfolio, "is something that might interest you before you proceed with this arrest." The credentials case was black leather, official-looking, with the kind of weight and quality that suggested federal authority rather than commercial production. She opened it slowly, deliberately, allowing the courtroom's tension to build toward whatever revelation would either vindicate Braxton's authority or destroy it completely. Gallery members leaned forward with collective breath held, recognizing that the next few seconds would determine whether they had witnessed justified enforcement of judicial authority or catastrophic abuse of power by someone who had finally challenged the wrong person. The silence in courtroom 2B was absolute, broken only by the mechanical hum of ventilation systems and the rapid breathing of people who understood they were witnessing something that would be discussed in legal and political circles for years to come. Judge Thaddeus Braxton was about to learn that some citizens possessed resources and authority that exceeded his own, and that 15 years of crushing defiant defendants had not prepared him for someone who could challenge his power from positions of strength rather than desperation. The lock clicks twice, then silence. The credentials case opened with practiced precision, revealing federal identification that transformed the atmosphere in the courtroom 2B more effectively than any explosive device. Done. Celeste Montgomery held the leather case at an angle that allowed Bailiff Ashford to read the official seal and photograph, her movement deliberate and unhurried despite the handcuffs that threatened her freedom. "Federal Bureau of Investigation," she said quietly, her voice carrying across the silent courtroom with devastating clarity. Dependent identification card, spouse of director Marcus Montgomery. The silence that followed was so complete that the mechanical hum of the ventilation system sounded like rushing water. Gallery members sat frozen in positions of strained attention, their minds struggling to process information that redefined everything they had witnessed over the past hour. Public Defender Wainwright's pen fell from nerveless fingers, clattering against her legal pad with sharp precision. Bailiff Ashford stopped mid-reach for his handcuffs, his experienced law enforcement instincts recognizing that he was entering territory requiring immediate supervisory consultation. The federal credentials explained everything: her extensive legal knowledge, her calm confidence under pressure, her references to federal review, and most importantly, her absolute certainty that constitutional violations would have consequences extending beyond local judicial politics. Judge Braxton stared at the credentials case with the expression of someone watching his entire world collapse in slow motion. His face underwent a series of color changes that suggested internal pressure systems approaching dangerous failure points. 15 years of absolute authority within these walls had not prepared him for confronting someone with direct access to the highest levels of federal law enforcement. That's impossible," he whispered, his voice barely audible above the courtroom's electric silence. District Attorney Pembroke had gone pale as winter morning, his political instincts recognizing catastrophic career implications. He dealt with federal prosecutors regularly, understood the jurisdictional complexities of civil rights cases, and could calculate the professional destruction that would follow from participating in the constitutional violation of an FBI director's spouse. "Your Honor," Pembroke said with barely controlled panic, "perhaps we should consider a recess to review the circumstances of this case." The suggestion was desperate damage control, an attempt to halt proceedings before they crossed lines that would require federal intervention and media attention. But Braxton was beyond strategic thinking, his rage and humiliation driving him toward decisions that would cement rather than mitigate his destruction. "I don't care if she's married to the president," Braxton snarled, his voice rising with each word. "In this courtroom, I am the authority and no one challenges my rulings without consequences." The declaration was judicial suicide delivered with theatrical flourish, spoken in front of 40 witnesses and a court reporter whose stenography machine was documenting every word for potential federal prosecutors. Braxton had just committed himself to a course of action that would transform a local traffic dispute into a federal civil rights case. Court reporter Eden Cross looked up from her machine with obvious alarm, understanding that she was transcribing what might become evidence in a federal investigation of judicial misconduct. Her fingers moved with mechanical precision, capturing Braxton's threat to arrest an FBI director's spouse for exercising constitutional rights. "Judge Braxton," Celeste said with calm authority that no longer suggested deference to his position, "you have an opportunity to step back from this precipice. I strongly recommend that you take it." Her tone had shifted completely from defendant to advisor, someone offering guidance from a position of institutional knowledge that exceeded his own. The transformation was so dramatic that several gallery members gasped audibly, finally understanding that they had been witnessing a performance rather than genuine vulnerability. "Bailiff, arrest this woman immediately or I'll find someone who will follow orders." Ashford stood frozen between competing authorities, his training in conflict with his survival instincts. Arresting an FBI director's spouse for citing constitutional law would likely end his career and possibly result in federal charges. But refusing a direct judicial order carried immediate disciplinary consequences. "Your Honor, maybe we should contact the court administrator before proceeding with—" "Now, bailiff!" Braxton's scream echoed through the courtroom with unhinged fury, his last vestiges of judicial temperament evaporating under pressure from someone who refused to be intimidated by his institutional power. The outburst was so explosive that several gallery members flinched reflexively. Celeste closed her credentials case with methodical care, returning it to her portfolio before addressing Ashford with professional courtesy. "Officer Ashford, I understand your difficult position, but before you proceed, I want you to understand that there are federal agents in the courthouse right now, monitoring these proceedings." The revelation hit the courtroom like a secondary explosion. Federal surveillance transformed their local judicial proceeding into something with national security implications, suggesting that Celeste's appearance was not accidental but part of a larger investigation of institutional misconduct. "That's impossible," Braxton stammered, his certainty cracking under mounting evidence that he was dealing with resources and authority structures beyond his experience. "Actually, it's standard protocol. When the spouse of a federal executive faces potential constitutional violations, Protective details monitor proceedings to ensure compliance with federal law. Her explanation was delivered with matter-of-fact authority that carried the weight of institutional knowledge rather than desperate improvisation. She wasn't threatening federal intervention. She was describing procedures that were already in motion. As if summoned by her words, the courtroom's rear doors opened with silent precision. Two men entered with the controlled efficiency of federal agents, their identical dark suits and professional demeanor radiating competent authority. They positioned themselves near the gallery's back row, hands clasped professionally, their presence transforming the local proceeding into something under federal scrutiny. The agent's appearance confirmed Celeste's claims while demonstrating resources that exceeded Braxton's ability to challenge or control. They said nothing, made no threatening gestures, simply stood as silent witnesses to constitutional violations that might require federal prosecution. Gallery members turned to stare at the federal presence with mixture of awe and terror, understanding that their morning traffic court had evolved into something that would likely attract national media attention. Some fumbled for cell phones, recognizing that they were witnessing events worthy of documentation. "Your Honor," Public Defender Wainwright said with newfound courage inspired by federal oversight, "I respectfully request that you reconsider the contempt charges against Dr. Montgomery. Her conduct has been professional and within constitutional parameters throughout these proceedings." Wainwright's intervention was professional courage backed by the presence of witnesses who could protect her from judicial retaliation. She understood that federal agents would document any attempts to punish her for advocating constitutional rights. "Miss Wainwright, if you continue to interfere with my courtroom, you'll join her in jail." The threat to imprison a public defender for exercising professional responsibilities in front of federal witnesses represented complete judicial breakdown. Braxton was committing prosecutable offenses while being observed by agents who could initiate criminal investigations. One of the federal agents removed a small recording device from his jacket pocket, not activating it but simply making its presence known. The gesture was subtle but unmistakable. Federal documentation was beginning, and further misconduct would be captured for prosecutorial review. "Judge Braxton," Celeste said with quiet finality, "you're being observed by federal agents who are documenting constitutional violations under color of law. Your next decision will determine whether this remains a local disciplinary matter or becomes a federal criminal case." The warning was delivered with professional courtesy, but its implications were devastating. Federal criminal prosecution could result in prison time, loss of pension, and permanent destruction of his reputation and career. Pembroke abandoned any pretense of prosecutorial neutrality, his political survival instincts overriding loyalty to judicial authority. "Your Honor, the prosecution respectfully requests dismissal of all charges against Dr. Montgomery." The about-face was so sudden and complete that it drew surprised murmurs from gallery members who had never seen a prosecutor abandon a case mid-proceeding. Pembroke understood that his career depended on distancing himself from constitutional violations that might attract federal prosecution. "You don't dismiss charges in my courtroom without my permission," Braxton roared, his authority crumbling while his desperation intensified. "Your Honor, the prosecution lacks confidence in the evidence supporting these charges." Pembroke's diplomatic language couldn't disguise the fact that he was abandoning ship before it struck the federal iceberg that would destroy everyone aboard. His withdrawal left Braxton isolated with his contempt charges and his rage. Court Clerk Meredith Vale approached the bench with obvious reluctance, understanding that her administrative functions were becoming evidence in potential federal prosecutions. "Your Honor, perhaps we should consider the broader implications of these proceedings." Even his court staff was advising retreat, recognizing that further escalation would destroy everyone associated with constitutional violations under federal observation. "I don't need advice from clerks, prosecutors, or federal agents," Braxton declared with magnificent oblivion to his deteriorating position. "This is my courtroom, and I will not be intimidated." The declaration was delivered with theatrical defiance to an audience that included federal agents documenting constitutional violations, a prosecutor who had withdrawn support, and 40 witnesses who were observing judicial misconduct in real time. Celeste gathered her portfolio with methodical precision, her movement suggesting someone who had anticipated this outcome and prepared accordingly. "Judge Braxton, your contempt order violates my constitutional rights under the 1st, 5th, 6th, and 14th Amendments. Your refusal to allow evidence presentation violates due process under Virginia Code Section 19.2-164. Your pattern of bias violates Canon 3 of the Virginia Code of Judicial Conduct." The comprehensive legal citation was delivered with academic precision, each violation documented for potential federal review. She wasn't pleading for mercy. She was building a prosecutorial case against judicial misconduct. Furthermore, she continued with devastating calm, your order to arrest me for citing constitutional law constitutes deprivation of rights under color of law, a federal felony under 18 U.S.C. Section 242. The federal statute citation was the final legal bomb in the quiet courtroom. Everyone present understood that 18 U.S.C. Section 242 carried prison time for officials who violated constitutional rights while acting in official capacity. One of the federal agents spoke quietly into a communication device, presumably reporting to supervisory personnel about the developing situation. The brief conversation suggested that higher authorities were being informed about potential federal crimes in progress. The tension is building to something massive. You can feel it, right? Judge Braxton has no idea what's about to hit him. Before we reveal the bombshell that will change everything, make sure you're subscribed because this channel brings you the most incredible real-life stories of justice and karma. Trust me, you won't see this next twist coming. Your Honor, Ashford said with obvious reluctance, federal agents are advising me that proceeding with this arrest could constitute participation in civil rights violations. The bailiff's admission that he was receiving legal advice from federal agents rather than following judicial orders marked the complete collapse of Braxton's authority within his own courtroom. Even his enforcement personnel were prioritizing federal guidance over local judicial commands. I am ordering you to arrest this defendant, and I am ordering those federal agents to leave my courtroom immediately. Braxton's attempt to expel federal agents demonstrated how completely he had lost touch with legal reality. Federal agents operating under protective authorities couldn't be dismissed by local judges, especially when documenting potential constitutional violations. The senior federal agent approached the bench with professional courtesy, his credentials case already open to display FBI authority that superseded local judicial power. Your Honor, we're operating under federal protective authorities. We're not subject to local judicial orders when monitoring potential civil rights violations. The agent's explanation was delivered with respectful formality that somehow made his authority more threatening than any aggressive display would have been. Federal power was asserting itself through professional competence rather than intimidation. This is a state courtroom handling state traffic violations. You have no jurisdiction here. Braxton's constitutional law understanding had collapsed under pressure, his desperation leading him to make legal arguments that revealed fundamental ignorance about federal authority in civil rights cases. Your Honor, federal jurisdiction applies when state officials violate constitutional rights under color of law. The Supreme Court established this principle in Monroe v. Papey, 1961. Celeste's Supreme Court citation was delivered with academic precision, demonstrating legal scholarship that exceeded most practicing attorneys. Her knowledge wasn't limited to traffic law or basic constitutional principles. She possessed comprehensive understanding of federal civil rights jurisprudence. The revelation that she could cite Supreme Court precedent on federal civil rights jurisdiction sent new shockwaves through the courtroom. Gallery members were witnessing someone who combined federal connections with legal expertise that rivaled professional advocates. Pembroke was frantically gathering his files, his retreat becoming more obvious with each passing moment. He understood that remaining associated with these proceedings would require explaining his role in constitutional violations to federal prosecutors. The prosecution withdraws all charges and respectfully requests immediate dismissal of this case. The formal withdrawal was prosecutors' equivalent of unconditional surrender, abandoning the traffic citation to avoid association with judicial misconduct that might attract federal prosecution. "You will not dismiss charges in my courtroom without my consent," Braxton screamed, his voice breaking with strain. "Your Honor, the prosecution has discretionary authority to withdraw charges when constitutional violations are apparent." Pembroke's response was delivered while backing toward the courtroom exit, his body language suggesting someone preparing for immediate evacuation. He had calculated that career survival required complete dissociation from Braxton's self-destructive course. The federal agents exchanged brief communication through subtle hand signals, their coordination suggesting prepared responses to escalating situations. They were not improvising. They were following protocols designed for exactly these circumstances. "Dr. Montgomery," the senior agent said with professional courtesy, "federal protective protocols are now in effect. Local authorities are advised that interference with your constitutional rights may result in federal prosecution." The formal declaration of federal protection transformed Celeste from local defendant to someone under federal authority that superseded Braxton's judicial power. She was no longer subject to his contempt orders or arrest threats. Wainwright stood with visible relief, understanding that federal oversight had created space for advocacy that would have been impossible under normal circumstances. Your Honor, I respectfully move for dismissal of all charges against Dr. Montgomery based on prosecutorial withdrawal and federal constitutional concerns. The motion was delivered with newfound confidence, backed by federal presence that could protect her from judicial retaliation. For the first time in years, she could advocate effectively without fear of professional destruction. Motion denied. This defendant will be held in contempt regardless of federal interference. Braxton's insistence on proceeding despite federal warnings and prosecutorial withdrawal demonstrated complete disconnection from legal reality. He was committing federal crimes while being observed by agents who could initiate immediate prosecution. Court reporter Cross looked up from her stenography machine with obvious distress, understanding that she was documenting judicial misconduct that would likely result in criminal charges and career destruction for everyone involved. Your Honor, I respectfully request clarification about my obligations to report these proceedings to appropriate authorities. The court reporter's question revealed another crack in Braxton's authority structure. Even administrative personnel were questioning their role in documenting potential federal crimes. You will report nothing without my specific authorization. Braxton's attempt to control documentation of his misconduct violated judicial ethics rules requiring transparent proceedings and accurate records. He was compounding constitutional violations with obstruction of justice. The senior federal agent spoke briefly into his communication device before addressing the court with formal authority. Your Honor, this proceeding is now under federal observation for potential civil rights violations. All participants are advised that their actions are being documented for possible prosecution under federal law. The formal notice transformed the local traffic court into a federal crime scene, with everyone present potentially subject to prosecution for participating in constitutional violations. The legal landscape had shifted from municipal traffic enforcement to federal civil rights protection. Gallery members began quietly evacuating, understanding that their presence might result in subpoenas to testify in federal prosecutions. Some fumbled with cell phones, recognizing that documenting these proceedings might be valuable for media outlets covering civil rights cases. The transformation of Courtroom 2B from routine traffic proceeding to federal civil rights investigation created an atmosphere of electric tension that seemed to charge the air itself. What had begun as a simple citation dispute had evolved into something with implications extending far beyond Fairfax County's judicial system. Dr. Celeste Montgomery stood at the defendant's podium with the composed authority of someone who had always possessed resources to challenge institutional power, but had chosen to fight this battle on purely constitutional grounds. Her federal credentials had been revealed not as a threat, but as an explanation for knowledge and courage that had seemed impossible for a typical citizen. Judge Thaddeus Braxton remained frozen behind his bench, his 15 years of unchallenged authority crumbling under scrutiny from federal agents who possessed both the legal knowledge and prosecutorial power to hold him accountable for constitutional violations. His face had settled into a waxy pallor that suggested someone approaching complete psychological breakdown. Your Honor, Celeste said with calm finality, you have repeatedly violated my constitutional rights, ignored relevant evidence, and threatened illegal imprisonment for exercising protected speech. You have done this while being observed by federal agents who are documenting your misconduct for potential prosecution. Her summary was delivered with academic precision, each accusation supported by documented evidence that federal prosecutors could use to establish criminal violations of civil rights law. She wasn't threatening prosecution, she was describing facts that made prosecution inevitable. The senior federal agent stepped forward with professional courtesy, his credentials case open to display authority that superseded all local judicial power. Judge Braxton, I'm Special Agent Parker Nash, Federal Bureau of Investigation. You're being advised that your conduct in this proceeding is under federal review for potential violations of 18 U.S.C. Section 242, Deprivation of Rights under Color of Law. The formal federal warning transformed Braxton from local judicial authority to potential federal defendant, someone whose actions were being evaluated for criminal prosecution. His immunity from challenge within Courtroom 2B had evaporated under federal oversight that could result in prison time. This is a state court handling state traffic matters, Braxton said with desperate attempts at authority. Federal agents have no jurisdiction over my judicial decisions. His constitutional law understanding had completely collapsed under pressure, leading him to make legal arguments that demonstrated fundamental ignorance about federal civil rights authority. Your Honor, federal jurisdiction applies when state officials violate constitutional rights while acting in official capacity. Your threats to imprison Dr. Montgomery for citing constitutional law constitute federal crimes regardless of state court setting. Agent Nash's explanation was delivered with respectful formality that made his authority more threatening than any aggressive display. Federal power was asserting itself through professional competence and legal precision. Bailiff Ashford had withdrawn to a position near the courtroom entrance, his law enforcement training recognizing that he was witnessing potential federal crimes that required careful documentation rather than intervention. He understood that his career depended on cooperating with federal agents rather than following judicial orders that might constitute criminal conspiracy. Public Defender Wainwright had abandoned any pretense of working on other cases, focusing completely on proceedings that might establish precedents affecting every future client. She understood that federal oversight had created unprecedented opportunity for challenging judicial misconduct that typically went unpunished. "Agent Nash," Wainwright said with newfound courage, "I respectfully request that federal authorities investigate Judge Braxton's pattern of discriminatory sentencing and constitutional violations affecting indigent defendants." The request for federal investigation of systematic judicial misconduct was delivered with professional precision, transforming isolated traffic court abuse into potential pattern or practice civil rights violations that could trigger comprehensive federal oversight. Braxton's rage reached explosive levels at the suggestion that his entire judicial career might be subject to federal review. "I will not tolerate this federal interference with state judicial authority. I order all federal agents to leave this courtroom immediately." The demand for federal withdrawal demonstrated complete disconnection from legal reality, his desperation driving him to make pronouncements that revealed how thoroughly he had lost control of both the situation and his judicial temperament. "Your Honor," Agent Nash replied with unchanged professional courtesy, "federal agents operating under civil rights authorities cannot be dismissed by state officials who are potentially violating federal law." The explanation was delivered without hostility or intimidation, making clear that federal authority was being exercised through legal process rather than arbitrary power. The contrast with Braxton's emotional volatility was stark and damaging. Court Clerk Vale approached the bench with obvious terror, understanding that her administrative role was becoming evidence in federal prosecutions that could destroy everyone associated with constitutional violations. "Your Honor, the court administrator is requesting immediate consultation about these proceedings." Even administrative supervisors were demanding intervention, recognizing that Braxton's conduct was creating legal liabilities that extended throughout the court system. His isolation was becoming complete. "I don't need consultation from administrators or federal agents. I am the authority in this courtroom." Braxton's declaration of absolute power in the face of federal oversight and administrative concerns revealed how completely his judgment had been compromised by rage and humiliation. Agent Nash spoke quietly into his communication device, presumably updating supervisory personnel about escalating federal crimes in progress. The conversation suggested that higher authorities were being informed about judicial misconduct requiring immediate intervention. "Dr. Montgomery," Nash said with professional courtesy, "federal protective authorities are implementing enhanced security protocols. You're advised that any further interference with your constitutional rights will result in immediate federal intervention." The formal declaration of enhanced federal protection marked the complete supersession of Braxton's authority by federal civil rights enforcement. Celeste was no longer subject to local judicial power that had been compromised by constitutional violations. "Your Honor," Celeste said with calm authority, "federal agents are prepared to document additional constitutional violations if you continue with illegal proceedings. I respectfully advise you to dismiss all charges and terminate this unconstitutional process." Her advice was delivered with matter-of-fact certainty, someone offering guidance from position of institutional knowledge that exceeded his own. The transformation from defendant to advisor was complete and devastating to his remaining authority. District Attorney Pembroke had completed his retreat to the courtroom exit, his abandonment of the prosecution becoming obvious to everyone present. He understood that career survival required complete dissociation from judicial misconduct under federal investigation. "The prosecution formally withdraws all charges and requests immediate case dismissal," he announced while positioning himself for rapid departure. The prosecutorial withdrawal was unconditional surrender, abandoning all aspects of the traffic case to avoid association with federal crimes in progress. "I will not dismiss these charges," Braxton roared, his voice breaking with strain. "This defendant will be held in contempt regardless of federal interference." The insistence on proceeding with contempt charges despite federal warnings and prosecutorial withdrawal represented complete judicial breakdown. Someone committing federal crimes while being documented by agents who could initiate immediate prosecution. Agent Nash exchanged hand signals with his partner. their coordination suggesting prepared responses to judicial misconduct that required federal intervention. They were following established protocols rather than improvising responses to unprecedented situations. Judge Braxton, you're being formally advised that continuing these proceedings may constitute obstruction of federal civil rights investigation in addition to the constitutional violations already documented. The federal warning was delivered with official formality that carried implicit threats of criminal prosecution for anyone who interfered with civil rights enforcement. Braxton was being offered final opportunity to withdraw before crossing lines that would require immediate federal action. Court reporter Cross had stopped her stenography, understanding that documenting additional judicial misconduct might make her complicit in federal crimes. Her withdrawal from official documentation marked another collapse in Braxton's authority structure. I order you to continue recording these proceedings, Braxton commanded with desperate attempts at control. Your Honor, I'm requesting legal guidance about my obligations when documenting potential federal crimes, Cross replied with obvious distress. Even administrative personnel were refusing to follow orders that might constitute participation in criminal conspiracy, leaving Braxton isolated with his rage and his determination to proceed despite universal opposition. The courtroom's atmosphere had become electric with tension and possibility. 40 witnesses understanding that they were observing institutional power being challenged by federal authority that could impose real consequences for constitutional violations. Gallery members had begun quiet evacuation, recognizing that remaining might result in subpoenas to testify in federal prosecutions of judicial misconduct. Some documented proceedings with cell phones, understanding that evidence of constitutional violations might be valuable for media coverage and civil rights advocacy. Dr. Montgomery, Agent Nash said with professional courtesy, federal protocols recommend that you withdraw from these proceedings to prevent additional constitutional violations. The suggestion was delivered as advice rather than command, but its implications were clear. Federal authorities were prepared to terminate local proceedings that had become criminal violations of civil rights law. Agent Nash, I appreciate federal protection, but I believe it's important to allow Judge Braxton the opportunity to correct his misconduct voluntarily before federal intervention becomes necessary. Celeste's response demonstrated remarkable grace under pressure, offering Braxton final opportunity for voluntary compliance despite his repeated violations of her constitutional rights. Her willingness to extend mercy to someone who had shown her none revealed character that made his misconduct more shameful by contrast. Your Honor, she said with quiet dignity, you have one final opportunity to dismiss these charges, acknowledge your constitutional violations, and begin the process of judicial accountability that might mitigate federal prosecution. The offer was delivered with professional courtesy, someone extending final opportunity for redemption to a person who had demonstrated consistent hostility toward her rights and dignity. Braxton stared at her with expression of someone whose entire worldview was collapsing in real time. 15 years of absolute authority within Courtroom 2B had not prepared him for confronting someone who possessed both the knowledge and resources to hold him accountable for abuse of power. This is impossible, he whispered, his voice barely audible above the courtroom's electric silence. Citizens don't have this kind of authority. The admission revealed his fundamental misunderstanding about constitutional government, his belief that judicial power was absolute rather than constrained by law and accountability to citizens whose rights he was sworn to protect. Your Honor, every citizen possesses constitutional rights that supersede local judicial authority. My federal connections don't create these rights. They simply ensure that violations will have consequences. Her explanation was delivered with educational precision. Someone teaching constitutional law to a judge who had forgotten that his power derived from and was limited by the Constitution he had sworn to uphold. Agent Nash approached the bench with formal credentials, his authority backed by federal law enforcement power that could impose immediate consequences for continued constitutional violations. Judge Braxton, this is your final warning before federal intervention becomes mandatory. Dismiss all charges against Dr. Montgomery and terminate these proceedings immediately. The ultimatum was delivered with professional courtesy that somehow made its authority more threatening than any aggressive display. Federal power was being exercised through legal process rather than arbitrary force. The silence in Courtroom 2B stretched until it seemed like the air itself might shatter from tension. 40 witnesses held their breath, understanding that the next few seconds would determine whether they had witnessed justified federal intervention or local judicial authority successfully resisting federal overreach. Braxton looked around his courtroom, seeing for the first time how completely his authority had evaporated. The prosecutor had fled, the bailiff had withdrawn, The court reporter had stopped documenting, and federal agents were prepared to arrest him for constitutional violations. Want to understand your constitutional rights like Dr. Montgomery clearly does? Masterclass offers courses from legal experts, former prosecutors, and civil rights attorneys who teach you how to navigate the justice system. Learn about your Miranda rights, court procedures, and how to protect yourself during police encounters. Get unlimited access to all Masterclass courses for just $10 a month at masterclass.com/rights. Knowledge is power, especially in a courtroom. Case dismissed, he whispered, his voice barely carrying beyond the bench. The words seemed to fall into vacuum, their legal impact enormous, but their delivery so quiet that several people weren't certain they had heard correctly. Your Honor, Agent Nash said with official formality, please state your ruling clearly for the record. All charges against Dr. Montgomery are dismissed with prejudice. This court finds no evidence of traffic violations and acknowledges constitutional concerns regarding these proceedings. The formal dismissal was delivered with mechanical precision, someone reading script prepared by others rather than expressing personal judgment. Braxton had capitulated completely, his authority replaced by federal supervision that would continue indefinitely. Celeste gathered her portfolio with methodical care, her victory complete but tempered by understanding that systematic problems extended far beyond individual judicial misconduct. Thank you, Your Honor. I hope this experience will contribute to improved constitutional compliance in future proceedings. Her gracious response to judicial capitulation demonstrated character that made Braxton's earlier hostility appear even more shameful. She was extending courtesy to someone who had repeatedly violated her rights and threatened her freedom. The gallery erupted in quiet conversation as people processed what they had witnessed. Federal intervention in local judicial misconduct, constitutional rights successfully defended against institutional power, and systematic problems exposed for potential reform. Public Defender Wainwright approached the bench with unprecedented confidence, understanding that federal oversight had created opportunity for advocacy that would have been impossible under normal circumstances. Your Honor, I respectfully request that federal authorities review similar cases involving constitutional violations and discriminatory sentencing patterns in this court. The request for comprehensive federal investigation was delivered with professional precision, transforming isolated traffic court incident into catalyst for systematic reform that might protect future defendants. Agent Nash documented the request with obvious approval, his expression suggesting that federal authorities had been monitoring judicial misconduct in multiple jurisdictions and were prepared to implement comprehensive oversight. Ms. Wainwright, Federal Civil Rights Division will be reviewing court records and interviewing affected parties about pattern or practice violations in this jurisdiction. The promise of federal investigation into systematic judicial misconduct represented victory extending far beyond Celeste's individual case, creating possibility for reform that might protect countless future defendants from constitutional violations. Braxton sat behind his bench in stunned silence, his 15 years of absolute authority replaced by federal oversight that would continue until constitutional compliance was established. His career was effectively over, his reputation destroyed, and his legal exposure extensive. Court personnel began evacuating with obvious relief, understanding that federal intervention had terminated proceedings that might have resulted in criminal charges for anyone who continued participating in constitutional violations. The immediate aftermath of federal intervention in Courtroom 2B created a vacuum of authority that would take months to fill properly. Judge Thaddeus Braxton's capitulation under federal pressure had terminated not only Dr. Celeste Montgomery's traffic case, but also his effective authority over future proceedings requiring constitutional compliance rather than arbitrary power. Dr. Montgomery departed the courthouse with Agent Nash and his partner providing discreet escort, their presence ensuring that no retaliation could occur while federal investigation processes were being implemented. She had achieved complete victory in her traffic case, while exposing systematic problems that would require comprehensive federal oversight to address properly. If this story of hidden power and ultimate justice blew your mind, wait until you see our next video about a CEO who fired a difficult employee, only to discover she was the daughter of the company's biggest investor. The revenge that followed was absolutely legendary. Hit subscribe and ring that bell so you never miss these amazing true stories. The news media response was immediate and extensive. Reporter Sage Whitmore from The Washington Post had been contacted by gallery members who recognized the national significance of federal intervention in local judicial misconduct. Her investigation would reveal patterns of constitutional violations extending far beyond individual traffic cases. FBI director's wife exposes judicial corruption in federal civil rights case. became the headline that transformed local traffic court incident into national discussion about systematic judicial misconduct and the need for enhanced federal oversight of constitutional violations. The Virginia State Bar Association launched immediate investigation of Braxton's judicial conduct, their inquiry expanding beyond individual constitutional violations to examine systematic patterns of discriminatory sentencing and abuse of judicial power. The Federal Civil Rights Division provided evidence and testimony that supported comprehensive disciplinary action. Public Defender Wainwright found herself at the center of reform efforts that extended throughout Virginia's court system. Federal authorities interviewed her extensively about judicial misconduct patterns, using her testimony to support pattern or practice investigations that might trigger systematic court monitoring and reform requirements. This case represents exactly why we need enhanced federal oversight of constitutional compliance in local court. Wainwright explained to federal investigators, Judge Braxton's misconduct was systematic, not isolated, and it affected hundreds of defendants who lacked resources to challenge violations effectively. Her advocacy contributed to federal decisions to implement comprehensive monitoring of judicial conduct in multiple Virginia jurisdictions, creating precedents that would protect future defendants from constitutional violations through enhanced accountability mechanisms. District Attorney Pembroke's career survived through immediate cooperation with federal authorities and complete disassociation from judicial misconduct. His office implemented new protocols for challenging judicial violations and protecting constitutional rights, reforms that might have prevented escalation if they had existed earlier. The Virginia Department of Corrections began reviewing cases involving defendants who had been sentenced by Braxton, identifying potentially unconstitutional convictions that might require federal intervention and individual relief. The scope of potential violations extended to hundreds of cases spanning multiple years. Officer Wickham faced internal investigation for perjury and civil rights violations. His traffic stop tactics examined for patterns of discriminatory enforcement that might support federal prosecution under Section 1983 Civil Rights Law. His body camera malfunction became evidence of deliberate evidence destruction that could result in federal charges. Court Clerk Vail and other administrative personnel provided extensive testimony to federal investigators about institutional culture that encouraged constitutional violations and discouraged accountability. Their cooperation contributed to comprehensive understanding of systematic problems requiring federal intervention. Bailiff Ashford received commendation from federal authorities for refusing to execute unconstitutional arrest orders, his decision to prioritize constitutional compliance over judicial authority becoming model for law enforcement personnel facing similar conflicts between local and federal requirements. The Fairfax County Court Administration implemented immediate reforms designed to prevent future constitutional violations, including enhanced training for judicial personnel, improved oversight of sentencing patterns, and protocols for challenging judicial misconduct when it occurred. Federal monitoring of court proceedings became a permanent feature of Fairfax County judicial operations, with civil rights attorneys observing cases and documenting compliance with constitutional requirements. The oversight was designed to prevent rather than simply prosecute constitutional violations. Dr. Montgomery returned to her work at the Smithsonian Institution with enhanced appreciation for constitutional protections that she had successfully defended through personal courage and institutional resources. Her case became a teaching example in law schools and civil rights training programs. Constitutional rights mean nothing without citizens willing to defend them, she explained to legal scholars studying her case. My federal connections provided protection, but every citizen possesses these same rights and should be able to exercise them without fear of retaliation. The civil rights implications extended beyond individual justice to systematic reform that might protect countless future defendants from judicial misconduct. Federal pattern or practice investigations were expanding to examine constitutional compliance in courts throughout Virginia and neighboring states. Community response was overwhelmingly positive, with civil rights organizations using the case to advocate for enhanced federal oversight of local judicial systems. The precedent established that federal intervention was available when state systems failed to protect constitutional rights adequately. Religious leaders, community activists, and legal advocates organized educational programs teaching citizens about constitutional rights and procedures for challenging violations when they occurred. The goal was preventing future misconduct through enhanced citizen knowledge rather than simply prosecuting violations after they happened. The American Civil Liberties Union filed federal lawsuit challenging systematic constitutional violations in Virginia courts. using evidence from Montgomery's case to support comprehensive relief that might protect all citizens from judicial misconduct. The litigation sought permanent federal oversight and mandatory training programs. Legal scholars began studying the case as an example of successful federal intervention in state judicial misconduct, analyzing factors that made constitutional enforcement effective and identifying strategies for preventing similar violations in other jurisdictions. The Department of Justice Civil Rights Division issued policy guidance clarifying federal authority to prosecute state officials who violated constitutional rights under color of law, using Montgomery's case as an example of successful enforcement that protected individual rights while encouraging systematic reform. Congressional hearings were scheduled to examine federal oversight of state court constitutional compliance, with Montgomery's case cited as evidence that enhanced monitoring and enforcement mechanisms were necessary to protect citizen rights effectively. However, systematic problems remained largely unresolved despite individual victory and media attention. Federal oversight was limited, reform implementation was slow, and many courts continued operating with minimal constitutional accountability until crisis forced intervention. The broader implications were troubling. Montgomery's case succeeded because she possessed exceptional resources and knowledge. But thousands of citizens facing similar violations lacked federal connections or legal expertise necessary to challenge judicial misconduct effectively. 6 months after the courtroom confrontation, mysterious developments began suggesting that constitutional problems extended far beyond individual judicial misconduct to systematic issues requiring comprehensive federal intervention and reform. A classified FBI memorandum marked redacted appeared in Montgomery's personal files, its contents dealing with nationwide judicial corruption networks that might involve federal prosecution of multiple judges and court administrators. The document suggested that her traffic case had exposed a small portion of much larger systematic problem. Anonymous telephone calls began reaching civil rights organizations, providing information about judicial misconduct in multiple states and suggesting coordination between corrupt court officials that might constitute federal racketeering violations requiring complex investigation and prosecution. Financial records subpoenaed during Braxton's investigation revealed suspicious payments from private probation companies to multiple judges throughout Virginia, suggesting systematic kickback schemes that converted constitutional violations into profitable enterprises for corrupt officials. Federal wiretap evidence collected during related investigations documented conversations between court administrators discussing strategies for avoiding federal oversight while continuing constitutional violations, suggesting that reform efforts were being actively undermined by institutional resistance. International banking records revealed offshore accounts connected to court officials in multiple states, suggesting that judicial corruption might involve foreign financial institutions and require cooperation with international law enforcement agencies to investigate properly. Congressional intelligence committees received briefings about potential foreign influence operations targeting American judicial systems, with Montgomery's case cited as example of how constitutional violations might serve broader destabilization objectives requiring national security investigation. The scope of potential systematic corruption was so extensive that federal authorities were struggling to determine appropriate investigation strategies, with some officials arguing for comprehensive nationwide review while others preferred targeted intervention in specific problematic jurisdictions. Political implications were significant. Comprehensive federal investigation of state court systems might trigger constitutional crisis about federal versus state authority, while limited intervention might allow systematic problems to continue affecting thousands of citizens annually. Legal experts debated whether existing federal civil rights laws provided adequate tools for addressing systematic judicial corruption, with some advocating for enhanced legislation while others argued that enforcement of existing law would be sufficient if properly funded and implemented. The ultimate resolution of systematic judicial misconduct remained uncertain, with Montgomery's individual victory serving as inspiration for reform efforts, while highlighting the enormous scope of institutional problems requiring sustained federal intervention and comprehensive political commitment to constitutional compliance. 3 months after media attention had faded, Dr. Montgomery received an anonymous package containing additional classified documents about judicial corruption networks, accompanied by handwritten notes stating, "This was just the beginning. The system runs deeper than anyone imagines." The package included financial records, surveillance photographs, and encrypted communications suggesting that judicial misconduct was being coordinated by organizations with resources and reach extending far beyond local court systems. The implications were staggering and potentially dangerous. Federal agents interviewed Montgomery about the anonymous package, their questions suggesting that her traffic case had attracted attention from groups involved in systematic corruption who might view her victory as threat requiring response. Her federal protection was quietly enhanced. The investigation was expanding beyond civil rights violations to examine potential organized crime involvement in judicial corruption, with federal prosecutors considering racketeering charges that might dismantle entire networks of corrupt officials and their financial supporters. International law enforcement agencies began sharing information about judicial corruption networks operating across national borders, suggesting that American court system problems might be connected to global organized crime activities requiring comprehensive international cooperation to address effectively. Congressional oversight committees received classified briefings about the expanding investigation, their questions focusing on whether existing federal authorities were adequate for addressing corruption that might involve foreign intelligence services and international criminal organizations. The full scope of systematic judicial misconduct remained hidden behind classifications and ongoing investigations, with Montgomery's traffic case representing a visible portion of problems that extended throughout American judicial systems in ways that threatened constitutional government itself. 6 months after her courtroom victory, Dr. Celeste Montgomery sat in her Smithsonian office reviewing acquisition documents for new civil rights exhibits, her work continuing despite awarenesses that her traffic case had exposed systematic problems requiring sustained federal attention and comprehensive reform efforts. Her desk telephone rang with distinctive tone that she had learned to recognize: federal secure communication requiring immediate attention to developing situations that might affect her safety or require her testimony in expanding investigations of judicial corruption networks. "Mrs. Montgomery," the voice said with official formality that carried implicit urgency, "we need to talk. New developments require your immediate consultation about the scope of judicial corruption that your case helped expose." The call suggested that federal investigations had discovered evidence connecting her traffic case to systematic corruption networks requiring enhanced protection and possible relocation while prosecutions were being developed and implemented. As she prepared to respond to federal requests for continued cooperation, Dr. Montgomery understood that her victory in traffic court had been beginning rather than end of confrontation with systematic problems that threatened constitutional government throughout American judicial systems. The lock clicks twice, then silence. But this time, the silence carries implications that extend far beyond individual justice to systematic reform that might protect constitutional rights for generations of citizens who lack her resources but deserve equal protection under law. The story continues in classified files, ongoing federal investigations, and systematic reform efforts that will determine whether American judicial systems can be restored to constitutional compliance or whether corruption has become too entrenched for peaceful resolution through legal process and democratic accountability.